Yeah, I gotta get that. All right, gentlemen, your appearances on Community Financial versus Neshwa.
Your Honor, Lee Meldy, P83783 on behalf of Community Financial.
Good morning, Grant Munson, P71994 for the defendant.
Good morning. What's scheduled today, fellas?
This is a pretrial, Your Honor.
And where are we at? You guys playing well together?
We're asking for 60 days discovery today, but yes, we are playing well.
I don't think
All
you'll be
right.
60.
You're okay with 60 days, Mr.
Yes.
Munson? We looking at written discovery, guys, or do you think there's depths involved?
I think just written.
Right.
All right, you want to just schedule another pretrial?
Sounds good to me.
Let's just adjourn the pretrial for at least 60 days out, give you a chance for some written discovery. Anything else we can handle today?
Nothing, Your Honor.
Nothing from me.
All right, have productive days, gentlemen.
Thank you.
Thank you. You too.
Thanks.
Hi, on the phone. What is your name, please?
Joyce White.
Joyce White.
Yes.
All righty. All right, I'm going to put you back in the waiting room. I do have you checked in, waiting for the other party to appear, okay?
Okay, thank you so very much.
You're welcome. Nerone Parker.
Yes, I'm here. Thank you. Sorry, be back.
Appearances on Spring Oaks versus Bell.
Morning, Your Honor. Aubrey Tobin.
Good morning, Your Honor. Cezanne Bar.
Go ahead, I'm sorry.
No, it's okay. Cezanne Barta, P65425 on behalf of plaintiff Spring Oaks Capital.
Good morning, Your Honor. Aubrey Tobin appearing on behalf of the defendant, Mr. Bell. And
All right, pretrial scheduled today, fellas?
Yes.
Yes, Your Honor. I'm requesting 60-day just to adjourn the pretrial. Mr. Tobin has claiming fraud. I believe that it is fraud. However, my client just has to take all the fraud information and do their own investigation before coming to a conclusion.
All right, so we're not talking about any depths.
Somebody else's behalf, not Mr. Bell. It's a matter of stolen identity, Your Honor.
Okay, so we're not talking about depths, just some written discovery, exchange some information.
Yes, and we've been doing that already.
Okay, we'll just get you a new pretrial date, 60 days out.
Thank you, Your Honor.
60 days out.
Thank you, Your Honor.
All right, good luck, gentlemen.
Thank you.
Mr. Sackler, are you ready? Mr. Ackerman, are you ready?
Yes, we're ready.
We're ready.
All right. Judge, are you still out there?
I am. What case is that?
This is preferred versus progressive, the very first one on the docket.
First file. Appearances, please.
Your Honor, Freddie Sackler appearing on behalf of Preferred Medical.
Good morning, Your Honor. Nicholas Ackerman appearing on behalf of Defendant Progressive, P number 85192.
All right. What do we got?
Judge, we're asking for 60 days discovery. We're going to mutually exchange some documents with each other and a motion date for motions for summary.
And the discovery will be using for either written and depositions if necessary.
Okay, do you want me to just adjourn the pretrial, or do you just want me to put a discovery period in with the idea somebody's gonna notice up a motion before we get to the end?
I think an adjournment of 60 days will probably be easiest. If we need to file a motion, we can simply file a motion and contact the court as to what date and time would work best. So
Yeah, any motion we're gonna file, Judge, will be post-discovery, so that's fine.
Okay, all right, so I'm just gonna adjourn the pretrial. I made a note for discovery, did not limit it to written, as long as that's by stipulation.
it's fine with me. Is that fine with you, brother counsel?
I mean, I'm not doing any depths, but if you guys want to do one, I don't care.
Okay.
Thanks,
Okay.
Judge.
Would you like an order for today, Your Honor, or will we simply just get a new notice for
I don't need an order at all.
Okay.
I don't need an order at all. If you guys want an order, send me one.
Okay. Thank you, Your Honor.
Have a great day. Anybody here on alternative lending?
I'm here on that one.
Counsel, your appearance, please.
Good morning, Your Honor. Mimi Kalish. My P number is 52383. This is the date and time for plaintiff's motion for summary disposition. This was a consumer loan. The defendant has failed to appear or to file a written response to the motion. I know
You
the
win.
court. Thank you, Your Honor. And I do have a revised proposed order than the one that's attached to our motion because he has made a payment. If I
Okay.
can submit that to the court, I'll upload it.
Please do label it as revised. That way, when I'm going through them all, I'll just ignore the one that doesn't say revised.
I will do so. Thank you, Judge.
Thank you. Enjoy your day.
Thank you. Cheers.
How about Downriver Community?
Yes, Your Honor. This is Terry Weishaus on behalf of the plaintiff, P86739.
All right, counsel, good morning. What do you got?
I believe that there is a non-appearance. We are here today for a show cause issued after a non-appearance for a creditor's exam. We would ask that the court enter a default judgment, or however the court would normally handle a situation such as this.
Well, if this is a creditor's show cause for failure to appear at a creditor's exam, I assume there's already a judgment in place.
Correct, Your Honor.
All right, and were both defendants required to be here today?
Yes, Your Honor.
And what's your judgment amount?
The judgment amount was $7,527.87.
I'm sorry, I blanked. I was trying to write something down. Give me the total again.
It's okay. $7,527.87.
Thank you. Let's see if a $3,500 bench warrant on each defendant will get their attention.
Thank you, Your Honor.
Have a nice day, counsel.
Thank you, Your Honor. I believe I have a 9 o'clock with Ms. Hillard.
Okay. Okay, let's wait and hopefully she'll show up.
She is here. I just didn't know that she was here for
Oh,
that
okay.
case.
You want to put the ladies in a breakout then?
Sure.
Appearance on Discover Bank versus Kapinski, please.
Yes, good morning, Your Honor. Stuart Best of the firm of Weltman, Weinberg, and Reese on behalf of the plaintiff. And again, to be clear, Your
Hi,
Honor,
counsel.
getting in for Daniel Best. So the record's cleared as Stuart Best, P40744.
Thank you. Ms. Kapinski, you can hear me okay?
Yep, I can.
Thank you. Counsel, what do you have?
Yes, good morning, Your Honor. This is our motion for summary disposition. The defendant has filed an answer. We've responded to the questions and issues. And furthermore, a motion for summary disposition does not have a response filed to it. We're requesting judgment this morning based on the motion itself, and it presented a proposed judgment of $9,753.22. This is on a Discover credit card, and that is the balance currently outstanding, including the costs and damages as set forth in the motion as a part of the proposed order.
No, actually go back. Just get on that for this one. All right, Ms. Kopinski, did you receive a copy of the motion that was filed?
Yes, I think.
Okay, and according to counsel, there's been no response filed by you. Is that correct? Or did you file a response and we've got to find it?
No, I had sent it. I'm working with a debt settlement company, so I sent all the information to them. I don't know what it is that they've sent back to you. I really don't know.
Okay, well, I've been in this business for over 30 years and I've never seen a debt settlement company file a response to a summary disposition motion. So I assume
Okay,
they
so
haven't filed one either.
Okay. I don't even know. So okay.
Okay. All right. So but you did get a copy of plaintiff's motion, so I'm going to give you a chance to respond to that motion orally today. Counsel, why don't you hit the high points of your motion?
Thank you, Your Honor. Once again, this is for a credit card debt that's outstanding. We've attached a copy of the contract as well as the outstanding balance. Furthermore, we've also attached the copies of statements on the account where charges were made against the account, and the amount set forth in our motion is the amount currently due, including all interest, costs, and fees as allowed by statute, as well as by the contract between the parties.
All right, why don't you give me that total? What does the plaintiff think is due on that contract now?
Yes, the total balance due is $9,753.22. That's damages in the amount of $9,620.43, cost the amount of $132.79.
All right, and the total was $9,753.22.
That's correct.
All right, and Ms. Kopinski, do you agree that you owe all, some, or none of that $9,753.22?
Oh, yeah.
I didn't hear your answer.
I said some.
Okay, how much?
Maybe 6,000.
And what's your argument against the other $3,700?
Listen, my fiance passed away, so this is where we're at.
I'm sorry for your loss, but I don't understand how your fiance passing
Sir,
away
I'm not
changes the
listen.
amount due.
Okay, then listen. I don't really have time to go back and forth with you guys. I try to do a debt settlement company. I don't know what's going on, and this is irritating
Okay,
me.
you can stop talking now. You can stop talking now.
I will. Okay.
I'm sorry you don't have time for this. Counsel,
That's not what I'm saying. I'm
granted.
saying that I've already tried to settle this.
Ma'am, I'm done listening to you. The motion's been granted. I'll sign the order. You get a copy of it. You can take that to your debt settlement company.
Thank you, Your Honor. Attached to our motion is a copy of proposed order. Would the court like that submitted differently?
No, as long as it's submitted on the e-file, we'll sign it.
All right. Thank you, Your Honor.
Judge, when you're done, next up is LVNV versus White at 9 o'clock.
All right, appearance for LVNV, please.
Yes, good morning, Judge Joseph Jamal here on behalf of the plaintiff, P71254.
Thank you, Mr. Jamal. What's scheduled for today?
We have a motion for summary scheduled for today.
And it looks like Ms. White did not appear today. Did you get a written response?
She is here, yes, Judge.
Oh, there she is. Okay, she's on the phone. She's on the phone. I'm looking for a face and she's on the phone. All right. Ms. White, can you hear me?
Yes.
All right. Did you get a copy of that motion filed by the funding company?
I had, only thing I got was the notice for the peer. What other thing that you mean did I get?
The plaintiffs filed a motion for summary disposition. You should have received a copy of that before you got a notice for today's date.
Oh, the package they sent me of all the invoices of the bills. I received that. Yes.
Probably. There probably was a document in that packet
Yes.
that's labeled.
Yes.
Okay. Okay. And I don't see anything in the court record, so I'm assuming you did not file a written response to that. Is that correct?
Correct.
Okay. Counsel, why don't you hit the high points and I'll give the lady a chance to respond orally.
Yeah, Judge, we did have a chance to discuss the matter before as well. I know defendant is working with the debt settlement company. We did have this previously adjourned, this motion. So I did mention to her that we may need to proceed today. With that being said, we have filed the motion based on MCR 2.116C10 primarily. We've included detailed account statements as well as any assignment related to the account. Furthermore, we do not have a response to that motion, so we would be seeking a judgment.
Okay. And what's the total amount according to your records?
$494.20 plus costs.
And what are your costs?
Costs, we have $35 filing fee, and I'm showing a service fee of $59.93.
You got a total or you want me to do the math?
I can do the total here. Give me just 1 minute.
Go
Your
ahead.
Honor. $589.13.
Thank you. Ms. White, do you agree that you owe that $589.13?
That's the total with what I owed, the filing and the, what else was it?
The total, this would be $589.13. That would include the court filing fee,
$490.
the court service fee, and the balance on your debt.
Yeah, but that's what it come to. I guess that's what I gotta pay.
Okay.
Yeah.
All right. So I'm assuming then you have no defense to the plaintiff's motion.
I would have to, like I said, I'm dealing with the debt solution. So this will be a total that presented to them on my behalf that I have to pay.
Okay. I'll take that as a yes, no defense.
Yeah.
All right. So
Okay.
I will grant plaintiff's motion. You'll get an order. I would suggest that you take that order to or share that order with your debt settlement folks as soon as you can. Counsel, did you already submit an order?
We have not, Your Honor. Do you want me to submit one on the 7-day rule?
Yeah, that'd be fine.
Okay, we will do that then.
Good luck, ma'am.
Thank you all.
Thank you. Thank you.
Heather, how about the first 8:45? I see it's 9:15 now.
At 8:45, let me bring in Miss Celia. She's the owner of Banna Toy Greenhouse. Keith
Okay.
Wiley did not appear.
Okay.
She's on.
All right, Banatoy, you got a camera you can activate? Benody Greenhouses, you got a camera? You're muted.
Okay. I just unmuted. Start video.
Okay, what's your name?
Cecilia Banity Brandmeyer.
Okay. And Miss Grandmeyer, is the Greenhouse Incorporated or an LLC?
Incorporated, a C Corp.
Okay, are you an attorney?
No.
Get one. You can't represent the corporation in a court of law. This is a court of law. I will adjourn today's hearing to give you a chance to do that if you'd like.
Okay, even though it's a civil court, I cannot
This is small
represent.
claims? Oh, okay, that's, all right, yeah, we can go forward with the small claims. It's unusual for me to have a small claims hearing on today's docket. So what's scheduled today? Ma'am, do you know what's scheduled for today?
Yes, the case number,
No, what's scheduled today? What was scheduled for today? What was supposed to happen today?
I got a notice in the mail.
Ma'am, I understand why you're here. I understand you get a notice, but what business do you have in front of the court today? This is your case, ma'am.
Well, the notice was for me to attend the Zoom meeting with Keith Wiley
For what purpose?
for the purpose of him not paying me that I had filed a seizure of property because I went through since September 23rd of last year.
Okay. Okay.
All the
So
documentation.
you filed a seizure order.
I'm sorry?
You filed a seizure order,
Yes.
right? And what happened with that?
Okay, and then I got the notice to appear
Okay.
for the
All right,
Zoom
Heather,
meeting.
put the lady back. Ma'am, I'll get to you when I get time to figure out what's going on because you obviously don't have a clue what's going on with your own file. So
Okay.
be patient and I'll try to help you when I get some of these other folks out of the way.
Okay.
I put her in the waiting room.
Yeah, and call downstairs and try to get somebody to figure out what's going on with this and let me know.
All right. Let me see. Oh, that's at 9:30.
How about Concordia? Oh, Concordia was a stip. I think I signed a stip on Concordia today.
Yep, those, so 8:45 is done, except we'll recall
Yep.
Miss Celia. At 9
Yep.
o'clock, we have Parkside versus Hillard,
Yep.
and they're on.
Appearances for Parkside.
Your Honor, this is Terry Weishaus, P number 86739 on behalf of plaintiff.
All right, and Miss Hillard, you can hear me okay?
Yes, good morning, Your Honor.
Good morning. All right, Ms. Weishaus, was this a default judgment?
Yes, there have been two default judgments from 2016 and 2022 in this case.
All right, so from that, I'm assuming the 2016 was set aside and then there was no answer filed again?
And there's been several motions on behalf of the defendant. I believe that that would be somewhat of how this had occurred. There was there have been claims that there's been identity theft to the original complaint that was, there was personal service done in June of 2016. And the original default was issued on August 23rd of 2016.
Right, and then that was set aside, I assume?
I assume as well that that was how it translated. There was a motion to set aside in September of 2021, and the new default judgment after another series of motions was issued on May 19th of 2022.
Okay, and the second default judgment was entered because Ms. Hillard failed to respond or failed to show up for a hearing. What happened? What was the cause of the second default? You know what?
Yes, it was.
Heather, hold on, counsel. Heather.
Yes, Judge.
All right, never mind. Never mind. I don't know what happened, but my Zoom page just disappeared. All right, counsel, try it again. Why was the second default entered if you know?
Yes, I believe that the defendant had claimed that on May 10th, she had shown up to a court appearance and it had been rescheduled to the 17th of May in 2022. And at that time, it was not, she did not appear to the rescheduled hearing. And so due to that, the default was entered on May 19th of 2022.
Okay. And Ms. Hillard, when I look at a motion to set aside a default judgment, there are two questions that have to be addressed. The first question is, do you have a good reason why you didn't do whatever led to the default? And in this case, it sounds like show up for a court hearing. The second question that I look at is, what is your defense to the underlying claim? Do you understand those questions?
I believe so, Your Honor, yes.
Okay, so go ahead and answer those questions in whatever order you'd like to.
So to the underlying claim, Your Honor, I am a victim of identity theft, which is why I didn't know about the suit for so long until I was actually garnished. I have a police report. I was not served even to the document that they sent me showing that I was served. It shows a different address from where I stayed, a different signature, even on my license. You can see the signature doesn't match, the address does not match. Even the description of me saying they served someone that's 110 pounds. I haven't been that weight since maybe I was 10 years old. So I'm not sure who they served, who took out the loan. I am a victim of identity theft. I never applied for, used, benefited from the loan or vehicle whatsoever. And I wasn't served. To address your second question, when I did present those facts the first time, you were gracious enough to set aside the motion. I did leave the country to help care for a very sick family friend who has passed since then. In that time being, I was under the assumption that, well, not the assumption, I was told by the court that the new motion to present our defenses was for May 10th when I called via phone. And because I was in Thailand, I didn't have, an American number. It would have cost too much. So I didn't have, I was talking with my mom. I did have her to call the court for me on that day to verify that I had court that day. She translated a message to me that they said I didn't have anything for that day. So because my address was, I had it forwarded to her house, I assumed that I would get an updated mailing, from the court saying when court would be, and I did never receive that. So to my knowledge, it just hadn't happened yet. I'm not a lawyer, Your Honor. I do appreciate what you guys all do here, lawyers and judges alike, but I don't understand the legal process all that much. And so I had been waiting to hear something back, and I just got back in the country on, at the end of this year. And so when I was able to resume and see, what happened, then that's what led to this, but it wasn't because, of just negligence. And so that's my response to both.
Let me make sure if I understand this or not. So
sure.
You had a hearing, you knew about a hearing that was scheduled for May 10th.
Correct.
All right. So you're out of the country and having communication issues. So you had your mother check to see if it was still on for May 10th.
Correct.
Okay. When did you do that?
When did I mean, she told me that it was on May 10th when she called into the court, and she said they didn't have anything with that case number for that day.
All right. So I'm assuming on May 10th, you were still in Thailand.
Correct.
So if your mother would have confirmed that you did in fact have a court date for May 10th, what were you going to do with it?
Well, I was assuming it would have been on Zoom.
Okay.
Yeah, I had internet access. I didn't have an American number. I didn't have the phone, so that's why I had her to phone in for me. But I did have internet access.
Okay. So on May 10th, you found out that the date had been adjourned to May 22nd?
No, I didn't. She told I was just going by the message. She told me that they said there was nothing on the docket for that court case for that day. So to me, it just, no one had got around to rescheduling. So I didn't know of an upcoming date.
All right. Counsel, at this point, I'm going to pass on this file. As you know, we're running on base, which is absolutely useless to me on the bench. So what I'm going to do, I'm going to pass on this file until I can look at the court register of action to see what was going on back in May. I'll be back with you as soon as I've had a chance to do that.
Thank you, Your Honor.
Heather, you got anything else that's ready to talk about now?
Yep. VSU versus SA Express.
All right, Mrs. Letopolsky, good morning.
Good morning, Your Honor. Greg Letopolsky for the plaintiff.
Good morning, Judge. May it please the court, John Eads for the defendant.
Your Honor, Mr. Eads.
Nice to see you, Judge.
What do we got, guys?
Your Honor, It's an interesting case. The liability is not disputed. The dispute is the amount of damages. I spoke with brother counsel, and we have an understanding what we might do with this case. Namely, my client will take the trailer, which is the subject matter of litigation, to a licensed dealer in Chicago to get it fixed, and his client will consider paying for it. There is no promises, but it sounds like it's the best way to go.
What do you want us to do? You want us to just adjourn things, or?
Yes, Your Honor. For 60 days, it should be
Okay.
sufficient.
How much time do we need, guys?
John.
60 days is fine, Judge. We appreciate
Okay.
the courtesy.
Yeah, fellas, I'll throw this option out there too, and this might be right for this. Liability is not an issue; it's just a question of damages. Judge Green and I have been kicking files back and forth for like an informal mediation process. After you get the trailer to the repair shop, if that doesn't resolve it, instead of coming back to see me, maybe what we need to do is just put you in front of Judge Green and see if she can't help your clients arrive at a party or a number that they're both unhappy with.
That sounds like a great idea, Judge.
Sounds like a great idea, Your Honor.
What was scheduled for today?
Pre-trial.
So let's just adjourn the pretrial for at least 60 days. Sounds like you guys are playing well together. So let's adjourn it for at least 60 days, and then you contact us and let us know what you want to do. You want to come back to see me for a pretrial, or you want to go right to Judge Green for an informal mediation?
That sounds great, Judge. We appreciate your help.
Make sense? All right,
Yes.
that might be
Makes
the
sense,
best way to get this resolved without a lot of legal fees. Okay, that's what we'll do.
Thank you, Your Honor.
Thank you, Judge.
Bye, John.
Have a
I'll
good
talk
week.
to you. Thanks.
You as well.
Mr. George, did you want to speak to your client?
Yes, please.
Okay, I'll bring him in just a minute.
Thank you.
Judge, next we have both parties for DNF versus Johnson.
Yep, 9:15.
Yep.
All right, appearances.
Good morning again, Your Honor. Lee Meldy, P83783 on behalf of the plaintiff DNF Associates.
And Rochelle Johnson.
Yes, I'm here.
All right, thank you. Counsel, what do we have today?
This is defendant's motion to dismiss, Your Honor. If I might interject here quick, I'm hearing some background noise from someone right now.
That might have been me moving my headset.
Okay, I'm not catching too much.
I can deal with it. It's fine.
Okay, now I think you got it. Ma'am, you filed a motion?
Yes, I did.
All right. Let's see if we can find it. Yeah. And counsel, there's a response from plaintiff?
Yes, we did file a response, and we served a copy of that response on the defendant, Your Honor.
Thank you. Did you see the response, ma'am?
Yes, I did.
Okay. All right.
Your Honor, may I address a preliminary matter?
Sure.
Thank you, Your Honor. I wanted to inquire about my motion to strike and reply declaration. It was submitted to your court last Thursday, April 11th. Have you seen that?
No. Is that different than the motion that we're arguing today?
Yes, I submitted.
Okay. Well, if you filed a motion and if it's not scheduled for discussion, that means the other side has not had a chance to review and respond. Would you agree?
Well, they responded to my motion to dismiss, and so I submitted a motion to strike and reply declaration in response to that.
We haven't received a copy of the motion to strike, and today is scheduled for a motion to dismiss.
Okay, let me ask you this, ma'am. What are you trying to strike?
Okay, first of all, are you going to swear us in?
Not yet.
Okay.
You're not testifying, ma'am. You're arguing. I don't have to swear you in for argument.
Okay. Well, the attorney is not telling the truth about the motion to strike.
Okay, ma'am. Ma'am, let's not make this any more difficult than it has to be.
Okay.
You
Sir,
filed a motion to strike last week. What was that attempting to strike?
it was in response to their reply to my motion to
Ma'am,
dismiss and
answer my
and sir,
question. Answer my
it was
question.
in
When someone filed a motion to strike, it's to strike something specific, like strike an answer. So what were you trying to strike last week?
their reply.
Their response to your motion to dismiss?
That is correct. And Mr. Meldy said that they did not receive my paperwork, and that's not true. I received confirmation that that was signed for Friday morning by Attorney Renner.
Okay,
can
well,
confirm
that's
with
not
you,
the
I have
attorney that's
not
on
received
Zoom
a
with us,
copy of
is it?
that. I apologize, Your Honor. I can confirm I have not received a copy of that motion to strike.
Okay, and Ms. Johnson, who signed for that?
Attorney Renner.
Revner?
It was signed for around 9 o'clock in the morning on Friday, April 12th by Attorney Renner. And I have
All right,
proof of it.
ma'am, I'm having trouble understanding you. I want to make sure I'm hearing the name correctly. Is it Attorney Renner, R-E-N-N-E-R?
Yes.
Okay, counsel, is there a Renner in your office?
That is the owner of the company, Your Honor.
Okay. All right, so is it possible somebody received it Friday and they just didn't get it to you by now?
I mean, we keep detailed records of everything. I'm not showing, I'm looking at this case file specifically, and I don't see any history notes related to receipt of any mail. There's no document attached. And
okay.
You know,
Ms. Johnson, do you have the ability to send that? Ma'am, do you have the ability to send that motion to strike to counsel electronically?
I have a link to that. Can I provide you guys the link or?
Okay, I don't know what a link to what you mean. It's in the cloud somewhere? I don't understand what you mean, a link.
Yes, I have it. I saved it to a Proton Drive link. I can provide the Proton Drive link.
Counsel, do you have any idea what she's talking about? Because I don't, because I'm not.
I have no idea. I would prefer if she does send it electronically. It's sent by email. Otherwise, if she can fax it, I can get the fax number.
Can you
Okay,
email or
that's
fax
fine.
that, ma'am?
Yes, I can.
All right. Counsel, you want to chat the email? You want to put it out on the World Wide Web?
I will chat that, Your Honor.
All right, Ms. Johnson, counsel's going to chat you an email. I want you to email him whatever documents you want us to review today and discuss. I want counsel to have a chance to look at those documents. Understood?
Okay.
All right,
Yes.
so I'm going to pass on the file until you do that. I'm going to move forward with my docket, and then we'll come back and readdress this. Hopefully, Mr. Meld has had a chance to look at your document.
Thank you, Your Honor.
Okay.
All right. Heather, what else you got?
Mr. George, are you ready for CG Stevens?
Could you just throw me in with her one more time, and then we'll be out in like 2 minutes.
All right.
Thank you.
No, Judge, I gotta call more people in, but
okay.
I don't have anybody from Old Cheese's office or Palin's office on Capital One versus Innocent.
Okay.
I have asked attorneys in the breakout room in the waiting room if they're for her, but nobody is.
Yeah, they've probably settled that, and we just don't have the documents yet.
Well, because Miss Palin is also on a 915 case. You know, let me bring Miss Harms in and see if she knows about Miss Palin. Hi, Miss Harms.
Hello.
Hi, have you been in contact with Jennifer Palin's office?
You know, I just texted her while sitting here. I saw your chat, and she's pretty responsive to me. I texted her cell phone, and no, I've not heard from her. So, but I wouldn't want to.
Appearances for Shilpa LLC versus Gary Robertson.
Morning, Your Honor. Ron Ruark for Shilpa.
And Ms. Gary Robertson, you can hear me?
Yes, good morning. How are you?
Wonderful. Counsel, what do we have today?
I think we have a consent, Your Honor. I'll put the terms on the record. The rent to
Go ahead.
Ready?
Yep.
The rent to retain possession is $11,850. $190 in court costs. Total judgment of possession only $12,040. $12,040. We're going to give Brittany until May the 7th to pay. And we're hoping that this gives her sufficient time to get her funding from
Can't hear
DHS.
anything.
All right, ma'am, did you explain the 3-day rule, Mr. Rourke?
Your Honor, I have not, so please do.
Okay. Okay. Ma'am, those terms that Mr. Rourke just put on the record, is that what you've agreed to?
Yes, I didn't hear him. I didn't hear nothing he said, but me and him talked. So if that's what he said, then yes.
Brittany, the total judgment.
Bottom line was
only.
the total number is $12,040.
Uh-huh.
You've got until May, what was the date, Mr. Rourke? May 17th?
May 7.
May 7. You've got until May 7.
Yes,
You
sir.
agree to those terms?
Yes,
Okay,
sir.
so that means either you come up with that $12,000 on or before May 7, or you move on or before May 7.
Yes, sir.
Okay, and you're agreeing to that today. Is it all right if Mr. Rourke signed your name to this paperwork?
Yes.
And understand you've got 3 days to change your mind, just like if we were selling you a vacuum door to door.
Okay, I agree.
Understood?
Yes, sir.
All right. And at some point in this process, did you watch a 20-minute video that explains your rights as a landlord, or excuse me, as a tenant?
I watched the very first video when I first came to court. Yes, yes, I did.
Okay. All right. Do you have any questions about the process, ma'am?
When can I pick up that paper so I can take it to DHS so I can get some help with assistance?
We should have that order signed today or tomorrow. So certainly, what's today? Wednesday.
Wednesday.
Tuesday. Today's Tuesday. So certainly by Thursday we'll have it.
And Your Honor, I'll submit it immediately.
And you can always call, I'm sorry, Mr. Rourke. Ma'am, you can always call the court and see if it's ready for you.
Okay.
Mr. Rourke?
I'll e-file it immediately, Your Honor.
Okay. So Mr. Rourke will probably have it in my file box online before I'm ready to get to it. So we should have it for you today or tomorrow.
Thank you so much.
All right. Any questions, ma'am?
No, sir.
Good luck to you.
Thanks,
Thank
Your
you.
Honor. Good luck, Brittany.
Thank you.
Thank you. How about Musville versus Stevens? Appearances, gentlemen.
Good morning, Your Honor. Attorney Adam Mortada, P number P83833 on behalf of the plaintiff.
Good morning, George of Lakeshore Legal Aid on behalf of defendant C.J. Stevens, who's present on Zoom.
Thank you, gentlemen. What do we got?
Your Honor, we did have a chance to speak. We've agreed to resolve possession by way of an interim order, which I will prepare and forward to Mr. Mortada. That'll just be the standard 10 days. And then we've agreed to sever the money judgment portion, and we are asking that the court adjourn that portion out to a date in early May so that we can engage in some informal discovery and explore settlement.
Sure. Heather, you got a date in early May?
Is this for
You
landlord
want to
tenant?
just call this a hearing on damages, or what do you want to call that?
That would be fine, Your Honor.
Heather, date?
Do we want your civil date, which is May 21st? Or
It should
do
be
we...
all right.
Okay.
So fellas, put all this in an order. The fact that you're separating possession, that we're going to meet on the certain date in May to talk about damages, put all that in one order if you would.
Yes, Your Honor.
Yes, Your Honor.
And I'm sorry, that was the 21st?
That it, Heather?
Correct, yes.
At
May
what time?
21.
You both of okay.
In the morning.
Yep.
Okay.
Okay.
And if we're actually going to have a damage on hearings or hearing on damages, I want it live. If you're going to stipulate to it all before then I'm okay with you just sending something in. But if we're gonna do damages, I'm going to want testimony. I'm going to want to see things in person.
Understandable, Your Honor.
That being the
anything
case
else we
here,
can do today, fellas?
That being the case, Your Honor, I wonder if we might have any time available in the afternoon. It would make my drive from Grand Rapids a lot easier.
Heather?
We do, yep, we do that day, Judge. We can do
Okay.
1:30.
That would be
that,
much
Mr.
better
George?
for me, if Mr. Mortada is available then.
Yeah, I can make it work.
1:30, perfect. Thank you so much.
Great. Love it when you play well together, fellas.
Thank you, Your Honor.
Thank you.
All right. Thank you both. Heather, we got anything else ready, or can I go back to Miss Banathy?
No, Country Meadows versus Gordeau.
9:45. Appearance?
Your Honor, for the record, Attorney Ian Morton, appellate on behalf of Country Meadows.
Thank you. And looks like we've got at least one Gordeau.
Yeah.
Gary, do you have a camera? If you do, can you activate it?
Yeah, I see you.
Well, I know you can see me, but that doesn't have anything to do with what I said.
Oh, start video. How about now?
If you don't have a, there you go. All right, there you go. You're good.
Okay.
All right, Mr. Morton, what do we have today?
The parties did agree to enter into proposed consent judgment agreement with Mr. Gordeau. The other two parties that are not present but are aware. Rents retained $3,000, $3,007.01. Court cost of $307.42. For a total of $33,14.43. We extended the normal statutory time period to the very end of the month at 4:30. I did advise him of his rights, specifically the fact it's not final for 3 business days. Second, the 10-day appeal, and he gave me permission to sign his name to the proposed consent judgment. I'm not sure if I went over this with him, but the idea would be other parties would be defaulted, but all the same terms, all the same amounts, no changes whatsoever.
All right. Mr. Gordeau, first of all, am I saying that name correctly?
Yes.
Thank you. Those terms that Mr. Morton just told me, is that what you've agreed to today?
Yes.
All right, you understand you've got 3 days to change your mind?
Yes, sir.
Yep, and you understand there'll be a default judgment with those same terms as to Tammy and Deborah.
Right.
And any questions?
No, sir.
Okay, we'll make it happen. I'm assuming you're going to send that in by e-file, counsel?
Absolutely, Your Honor. I'll be submitting that once I'm done. Once we eventually, call my other case. So.
Got it. Okay, Mr. Gordeau, we'll get that probably be signed today or tomorrow.
Okay, thank you, sir.
Good luck to you, sir.
All right, thanks. Am I done?
You are, sir. Enjoy your day.
Okay,
Mr.
bye-bye.
Morton, is that next one Holiday West versus Peltzer?
That is correct, Your Honor.
All right, and do we have a defendant?
No, not yet.
No, nothing I'm aware of.
All right. All right, so let's wait a few minutes, see if we get one, Mr. Morton.
Understood.
Heather, anything else ready?
Parks at Concord versus Price.
Appearance on Parks?
Good afternoon. Good morning, Your Honor. Mark Swessinger, standing in for the attorney of record on behalf of plaintiff.
Thank you. Mr. Price, you there?
Yeah, I'm here. I had to fix my
Thank
thing. I'm
you.
here.
All right, counsel, what do you got?
Your Honor, I've talked to Mr. Price. We have worked out the terms of the consent judgment. The terms are as follows. This is possession and money judgment, Your Honor. Current rent to retain $5,625.41. Court cost $247.79. Total to retain and the total for the money judgment $5,873.20. I've moved the writ date out to 4/30/2024. I did explain MCR 4.201J to Mr. Price and did receive his concurrence to sign his name to this proposed consent judgment.
All right, and Mr. Price, those terms,
Yes.
is that what you've agreed to today?
Yes, Your Honor.
You understand you got 3 days to change your mind?
Yes, I do.
Any questions?
None.
All right, I'll get it signed as soon as I can get to it.
All right.
Good luck, sir.
Thank you.
Thanks, Judge. Good luck, Mr. Price.
Thank you.
You
have a
got
good
it. You too, sir. Thank you.
Judge, at 9:30, we have credit acceptance versus Weston.
Yep. Appearance?
Good morning, Your Honor. Lisa Ledger, P80871, standing in for attorney of record Richard Rusin for the plaintiff.
Thank you. Mr. Weston, you can hear me okay?
Yes, sir.
Thank you. And Mr. Weston is, I think today's scheduled because you've objected to a garnishment?
Yes, sir.
Okay. And I don't know how fast you can find that. Let me get my hands on that document you filed, sir.
All right, Your Honor, I am happy to report that we have come to an agreement outside of the garnishment, if Your Honor would be interested.
Perfect.
Okay,
Tell me
Your
about
Honor.
it.
So they have already taken 2 payments out, but my client is willing to suspend the garnishment and accept payments of $500 per month as an installment payment plan. And
Right.
provided those 2 payments get to my client, that I think one came out on the 5th and another one's coming out this week, we would allow the payments to start on the 25th of May. As we know, he's already had the substantial deductions from his paycheck this month. So we'll let him take the month to get his finances together, and we can do 500 months starting May 25th. And of course, if those payments don't come through, we would file a motion for to set aside the payment plan and ask the garnishee to take that garnishment out of suspension and reissue.
All right. So I'm just going to make a note that an agreement has been reached and an order will follow.
Absolutely, Your Honor.
All right, Mr. Weston, counsel's going to send me an order and I'll get a signature on it. Understood?
Yes, sir.
Any questions?
No, sir.
All right. Have a nice day.
Thank you so much,
Thank
Your
you.
Honor. Have a wonderful day.
Thank you.
You're
Bye-bye,
welcome,
everyone.
sir. Heather?
That's it. If you want to recall the DNF versus Johnson, and then we can go to Miss Hillard's case. At the 915 DNF versus Johnson.
Yeah, what were we doing with that one?
You wanted to reschedule. Mr. Miss
That's
Johnson.
all the paperwork. Yeah, that's all the paperwork. Yep, thank you. Yep. DNF versus Johnson, please.
Lee Meldy, Your Honor, P83783 on behalf of the plaintiff, DNF Associates.
All right, counsel, I've got my hands on what was filed Thursday, and it's 32 pages long. So I don't know if you received the email or not, but I'm not going to make you digest that today.
Yeah, I reviewed a couple of pages of it. I mean, my document's 40 pages long.
Yeah.
And it's not addressed
So
to be.
Here's what we're going to do. Here's what we're going to do. Heather, what's the date?
Do you want it just on your next civil, May 21st, or you wanted it soon? Okay, May 21st.
All right. You two get to come see our new courthouse. I'll deal with all this on May 21st. I can give you a morning time or an afternoon time.
I would prefer afternoon, Your Honor, since I'll be coming from Grand Rapids.
You should probably talk to Mr. George. Maybe one of you guys could save the drive and send the other one down for you. How about 2 o'clock?
That's fine, Your Honor.
Ms. Johnson, 2 o'clock on the 21st?
Yes, Your Honor.
All right. We'll see you both then.
Thank you.
You're welcome, ma'am. Heather, can I go back to Miss Banatee?
Parkside versus Hillard. That one.
What were we doing with that one?
You were going to look over the paperwork.
Oh, that's the ROA I want to look at.
Yeah.
Let me deal with Miss Banatee. We got too much stuff we've been shuffling around.
What's
Let me deal with
Banatee?
Miss Banatee while.
What case is that?
First one at 8:45. Greenhouse versus Wiley.
Okay, let me bring her in. Thank you. She's in, Judge.
All right, ma'am. First of all, pronounce your name for me. I always pronounce it Benotti.
Banatee, like vanity.
Banatee. All right. All right. Banatee. All right. Well, that delay gave me a chance to figure out why you're here today. And basically it's because we're confused. You filed your original affidavit and said that there was $6,802 and change due. And then we've got a judgment. Hold on a minute. I'm going to give you a date on that. There was a default judgment entered on February 15, 24 for $6,645. And then most recently, we've got a request in order to seize property that lists the judgment amount at $6,800. and then showed interest of $1,165 and costs of $209. So none of these numbers are making sense to me. So I've got to figure out where all these different numbers are coming from.
Okay, when I had filed the seizure of property, Judge Green had said you cannot collect interest from the money judgment from the time when they owed you the money. It had to be from the time you had originally filed. So I had to go back and recalculate. That's why the numbers have changed.
There's pre-judgment and there's post-judgment. Okay, so anything pre-judgment would have been included or should have been included in the default judgment. You follow me?
Oh, okay. When you say the pre-judgment was what I had originally added the interest from the time when he owed me the money, not from the time I originally filed. Is that correct?
Correct. That would be part of the claim you're making in the small claims case is, for example, and I haven't looked at all your paperwork, but for example, if I go get my car repaired at the dealership, there's a little segment on the invoice that says, you know, payment is due within 10 days. If not, it's going to be 1% a month every month or whatever it is. Okay. So if they sue me a year later, they're going to sue me for the $1,200 repair bill plus the 12 months of interest. You follow me?
Right.
That's hashed out in the lawsuit. They get a judgment against me for 14 grand, for example.
Right.
And now the interest they're entitled to is usually a different amount than they might have been entitled to before the judgment. Post-judgment interest is kind of a scale that's based on the treasury bills, and it changes, I think, I don't remember now, I think every 6 months. So that's like a moving target.
Right.
Usually the pre-judgment interest is set by contract between the parties. So where we're at today is you've got a judgment for $6,645. Now you're trying to collect on that judgment with seizure of property, correct?
Correct.
So I've got to get to a point where I can justify the number on that request in order to seize property. So we start with the $6,645.
Okay.
That was, I already forgot the date. That was dated 2/5, February 5.
2/5. Okay.
Because I can't tell you what the post-judgment interest is because I don't do the calculation.
Okay.
So since February 5, you're entitled to post-judgment interest on your $6,645. So I'll leave it to you to do your research, figure out what that post-judgment interest is. Let's talk about costs. You've listed $209.90 in cost since the judgment. What are those fees that add up to $209?
Okay, that is for the court cost.
What court cost, ma'am?
Okay, my filings and also
that's all supposed to be part of your judgment, ma'am.
I'm sorry?
Your original filing fee, your original court cost, those are all supposed to be part of your judgment award. The costs that you're entitled to now are post-judgment costs. In other words, costs you've incurred since February 5th, 2024.
Oh, okay. Okay.
So we've got the judgment amount of $6,645. We've got the interest rate, and when you submit this, I want you to show how you calculate it. What rate, how many days, so on and so forth. Then you've got your post-judgment costs. For example, whatever it costs you to file this request in order to seize property, I think it's $20 or $25. You're entitled to that. Okay? Then the next line on the form is a deduction for whatever payments Mr. Wiley has made. Then that gets you to a bottom line, and that's what the court officer is going to be authorized to go out and collect by seizing property. Do you understand that?
Okay. Okay. Yeah,
Okay.
because
Now, go ahead.
Okay, because I just wanted to be clear that the original on 9/23 that I had submitted, the claim, okay, that had included that interest prior, and then Judge Green wanted me to only redo the interest to show interest starting through the that treasury
I'm gonna cut you
calculation
off. I'm gonna
from
cut you off.
9.
I don't know what Judge Green did, but here's where we're at. You've got a judgment for $6,645. That's the number you start with. If you want a different number on your judgment, then we're gonna have to file a motion. We're gonna have to notify Mr. Wiley that you're after more money than that $6,645. It's
Okay.
probably not worth it, but that's an option. You have an option as plaintiff.
Right, and I'm not going to do that.
Okay. So do you have any more questions about what we've got going today and how you need to proceed to get that request in order?
Okay,
signed?
so I need to go back, do the recalculations, go back and have the form MC-19 filled out again and submit
Right,
it.
and I want you to show your interest calculations.
Okay. And then just to summarize again, number 1 was the original 6645 in there.
Judgment amount.
Okay, the judgment amount,
Right,
and then number 2,
right.
the total amount of judgment interest accrued is only
Post-judgment interest, correct.
is
And let's see if we can get you a little help right now. Let's see if we can get you a little help. Any attorneys out there that know what the current post-judgment interest rate is? Not enough collections attorneys listening.
5.39, Your Honor.
5.39?
Correct, Your Honor, give or take.
Thank you, counsel. All right, ma'am. So that just saved you probably an hour worth of internet searching. So the interest rate since February 5th is 5.39%.
okay.
You follow?
Right, but Judge Oakley, what I'm trying to say is number 2 is only from the February date to current for
Correct.
that interest.
Correct.
Okay, got it. I got it. That's clear
Okay.
to me. Thank you.
Okay.
And then the total
then
amount.
the cost line is only what expenses you've incurred since February 5th, and you can break those down too.
Okay, well, since the February 5th, so I don't show VIX costs at 209.90 in there.
Yeah, but you told me the 209 was part of it was your filing fee for the original small claims action.
Correct.
You don't get that now. That's supposed to be part of your original judgment. It's post February 5th costs.
Okay.
All right. Any other questions?
Okay, and then the total amount of post/judgment payments made is 0 from the defendant.
Mr. Wiley. Right?
Okay, and then whatever the total cost. Okay, got
Whatever
it.
the math is.
Okay.
Any questions?
Nope, that's
Okay,
clear.
ma'am, I'm going to say this with the utmost respect. You're absolutely crazy if you're in the business you're in and you don't have an attorney.
Okay.
I've been very, very patient with you today. It's not going to happen next time.
Okay, I appreciate that.
You're welcome. I mean that sincerely. You're welcome. But you filed as a corporation, even though you don't need an attorney in small claims actions, you're not always going to get a court that's going to walk you through the process like this.
Okay.
You need to have an attorney that you can call and say, look, I got a $6,600 judgment against this guy in small claims. What's my next step and how do I do it so I can get it done the first time? You've spent hours with my staff trying to get this order in place, haven't you?
Yes.
As a small business owner, your time is more valuable than that.
Okay. I appreciate
At my
that.
advanced age, I've just determined that just about all life's most important issues come down to a math problem. This is a math problem. You had an attorney that you dealt with on a regular basis. It probably wouldn't have cost you $200 to get all this right the first time. So when you filed it, the court officer was already out there looking for your money.
Okay. I appreciate it.
You're welcome. Good luck to you, ma'am.
Okay, thank you so much.
You're welcome. So on that one, just make a note that Oakley School plaintiff, she's going to refile. Heather, we got anything?
Nope, you're just Parkside versus Hillard is next, and then the four
Okay.
people in the waiting room
Are
are
you
all
ready
on the
on
same
that?
case at
Hillard?
10.
The ROA? Oh, yes. All right, I've got, let's look at Parkside again.
Your Honor.
Recalling Parkside versus Hillard appearances.
Yes, Your Honor. This
Your
is
Honor.
Carrie Weishaus on behalf of the plaintiff, P86739.
All right, Ms. Hillard, let's talk some dates again now that I've actually got the court's register of action in front of me.
Yes, Your Honor.
When was that date scheduled that your mom checked on?
May 10th,
Of
2022.
22. Thank you.
Correct.
What is that 10 o'clock? Go talk to her about it. What is it? What's the attorney's name? Go talk to her. She'll figure it out. Okay, counsel, response on behalf of plaintiff, please.
Yes, Your Honor. There are several issues, I believe, that are going on here. The original complaint and issue was addressed in 2016. However, the defendant claims that there was some type of identity theft. She has told me during our conference that she had filed a 2017 police report. However, it is unclear to me what would be on that police report as far as what would be brought to her attention as far as identity theft at that time. It has not been produced. We did send interrogatories to one of her several motions for different objections to garnishment and motions to set aside. Those interrogatories were sent out on May 3rd, 2022. Those were not returned. We have not had any response or any type of documentation showing her claims as far as identity theft or the police report that was filed in 2017 as she has claimed. The May 10th hearing, May 10th, 2022 hearing was rescheduled and notice was sent out the following day on May 11th. So the non-appearance is certainly not reasonable to believe that she had made reasonable efforts to see about that rescheduling, as well as the response as far as after that in a timely fashion. It's almost 2 years since that time of that hearing. And what seems to be happening is that she had a garnishment in May of 2021, and there was a slew of litigation or filings after that time in response to her income tax garnishment, as well as has been an income tax garnishment on her 2023 income tax return. And it seems to be a trend of having this. And the common theme seems to be, I wasn't aware of the hearing and there was identity theft. And it seems to be something that, certainly the time for discovery and the time to have addressed this and produced documents showing that there was identity theft has passed, as well as it not being a timely filing by any means, and not seeming that there is any true good cause here for this motion.
Thank you, Counsel. Ms. Hillard, I'll give you a chance to respond, if you choose.
Yes, Your Honor. In response, I just have to say, I've not, as far as a notice being sent out, if I wasn't in the country, I wouldn't have got that notice. I did the best that I could at the time, which was having my mom to check on things for me. I am a victim of identity theft. They've not requested anything from me, which I assume we would just go through court about. And again, even with serving, the address that they have on file, I have my license, and I just was speaking with the attorney about that. It shows a different signature. It shows a different address. It shows a different weight. It shows all of these different things that don't.
I could care less about the original lawsuit service. We're way past that.
Sure. Okay. So yeah. So like I said, I do have proof that I was a victim of identity theft. When I called the court last, I spoke to them. The hearing was May 10th. At the time, because I wasn't in the country, I relied on my mom to check on it for me and was told that there was no hearing that day. And so because my mail was being forwarded to her, I did assume that she would receive mail from me and that I would be updated. Since then, I couldn't do anything until I actually came back home, which I am here now. So to me, that's a reasonable amount of time, because as soon as I was able to, I did actually check on things. And that's my response.
Okay.
You know, like I said, I'm not a lawyer. I did the best that I could. Okay.
Your motion is denied. The fact that you choose to live out of the country is not the plaintiff's problem. You've had 3 defaults entered against you. This is the 3rd default that you now want to set aside. Yeah, there was a default judgment entered. Ma'am, I'm not going to argue. Your motion's been denied. I don't think there's good cause to set it aside, so I don't even have to get to your meritorious defense. Your motion is denied. The judgment will stand. Counsel, submit an order.
Yes,
you can appeal my decision. You just can't argue with it.
No, I don't want to. I just wanted to ask you a question. I'm not trying to argue or anything. You said 2 from what I saw in the court. I only filed 1 motion to set aside default previous to this one. So you're saying there's 3 defaults? Okay,
ma'am, I've denied your motion. The judgment will stand. Feel free to appeal me. The circuit court judges need work as well. Have a nice day.
Thank you, Your
Heather,
Honor.
what do you got?
I'm bringing them in now. It's the 10 o'clock case, Komodo.
In the opening portion of the transcript, the court moves swiftly through 2 connected but distinct matters, setting the tone for a fast-paced docket. The first case is brief and procedural in nature. The judge addresses a filing error and makes it clear that the issue could have been avoided with proper legal guidance. Rather than dwelling on the substance, the court simply notes that the matter will be refiled, signaling closure without controversy. This exchange highlights the court's expectation that parties take responsibility for proper filings and follow procedure carefully. The second case, Parkside v. Hillard, carries more substance and tension. Here, the court deals with a defendant attempting to set aside a default judgment. The plaintiff's counsel lays out a detailed history, emphasizing missed deadlines, unanswered discovery requests, and a pattern of delay stretching back years. The defendant argues identity theft and lack of notice, explaining that she was out of the country and relied on a family member to monitor the case. However, the judge focuses on consistency and responsibility, pointing out that multiple defaults have already occurred. Ultimately, the court finds no good cause to reopen the matter and denies the motion. The ruling underscores a recurring theme: courts may be sympathetic to hardship, but repeated inaction and procedural failures carry serious consequences.